This is TWiT.
Do you want to start with, we should, with the Andy Warhol case?
Well,
yes?
do you want to do the good news or the bad news first?
Well, let's state the facts of the case.
Okay, well, the Warhol is the all bad news case. The other stuff on the 230 front was the surprisingly good news case.
Yeah, well, let's start with the bad news first.
All right, oh gosh.
So, photographer Lynn Goldsmith in 1981 took a picture of Prince.
Yes.
That's what's on the left if you're watching the video. Andy Warhol on a commission from...
Variety, I think.
I can't remember. It was a Condé Nast publication.
Condé Nast ended up later, and I don't know if
later.
Okay. But I don't know if there's
It was for Vanity Fair later. Anyway, they commissioned these 16 silkscreen images clearly taken from the original Lynn Goldsmith photograph. And the position of Andy Warhol's estate was, and your position too, right? You wrote an amicus brief for this one.
So so Andy Warhol made those silkscreen adaptations of the Goldsmith photo while he was alive. At some point while he was alive, and I think he died in 1987.
It's hard to make them when you're not alive. Let's just
and
say
that is a
I'll stipulate
fact that is
Your Honor.
largely overlooked in this decision, and it sort of should matter. And I don't mean sort of; it should have mattered. So essentially, they describe briefly the successor in interest to him, which was he had a foundation, the Andy Warhol Foundation. I guess basically owns the copyrights in his works. And he was approached by Condé Nast because Prince now had died and they wanted to do an article about him. And they had a choice of like, well, what
when you said he was alive, you didn't mean Andy Warhol, you meant Prince.
Sorry, no, Andy Warhol. Okay.
I was confused. I thought she said Andy Warhol made these prints while he was alive. You meant while Prince was alive.
No, Andy Warhol, when he was alive, made his own works. He did not make them after he died. And that
makes sense.
Okay.
That's how it's usually done.
So Prince also was alive.
Because he made the prints. It's also confusing because there's Prince.
The Prince.
He made the silk screens. We'll go with that. He made the silk screens.
The images.
He made the images and while he was alive, and they got published somewhere, but then
everything was okay then.
And everything apparently was okay.
Nobody complained. Lynn Goldsmith didn't complain. Nobody complained.
Right. Then 20 years after Warhol died, Prince now died. And so Condé Nast wanted to illustrate the article they had on Prince. And they went to the Andy Warhol Foundation, which now was the successor in interest for the rights in Andy Warhol's works. And they said, can we license that? And the foundation said, great, give us $10,000, I think. And then Goldsmith found out about this and started to threaten them in some way. And so the foundation sued for declaratory judgment to say, well, this should be fair use, so you shouldn't have a leg to stand on, and let's just have the courts rule on this now. And the district court said, you're right, it's fair use, nothing to see here. And then the Second Circuit undid that in a decision that really abandoned what the Supreme Court had said in the Campbell versus Acuff-Rose case, which was the one where Two Live Crew had
sampled the music,
satirized the "Oh Pretty Woman," Roy Orbison's song.
Although, by the way, that word satirized.
Yeah, I may actually be saying it wrong, whether it's satirize or parody, but I think it's all dumb either way you slice it. So I hate to give it that dignity.
If they just used it in the production, that wouldn't be fair use. But if they were satirizing or parodying it, like Weird Al does, that would be fair use. But only. Because the only reason I say this is because we are always thinking about fair use here, only if it parodies the original creator of it.
So
you can't use it to make a separate. It's too complicated.
Well, no, I mean, it's also too hard to figure out what the court just said. But in theory, the idea is in the statute, it talks about one of the things that makes things more likely to be fair use is if it's commentary. And so the interpretation is, okay, if you're commenting on the original, you got to be able to use the original. So that's more likely. Yes. It is less clear whether commenting on anything else would be fair use. And this decision seems to drive a stake through the heart of the idea that you could comment on anything else using a previously existing work. But that's going to fall apart in practice and be awfully chilling for anybody who. The expression is.
Let me just because we're using this phrase, I want to explain what it is so people understand what the phrase "fair use" is. It is not a law, but it's a doctrine, right? It's a point of view that says you can, in a limited fashion, use somebody else's copyrighted material without permission providing it satisfies one of,
it is part of the law.
It is in the law.
It is in the law. So before the
17 U.S.C. 107.
Yeah, before the 1976 Act, it was interpreted to be part of the law.
But it's now in 76.
But they codified it. They used a lot of what the factors the judges were using to consider whether something was fair use or not, and then they baked them into the statute with the 1976 Act, which is basically what we're using now. And so fair use is there. It is part of the law, and it inherently, so what's in the law is if you have a copyright, there's some exclusive rights you get as part of a copyright, subject to other limitations, including the ones articulated in 107, and 107 talks about fair use. So fair use, and courts go back and forth with good language or bad language, but there is a take on this that your copyright is inherently limited by things that the public can still do.
And there's reasons for that, because it's in society's interest. There's two interests, conflicting interests. The creator of the original work has an interest in protecting their rights so they can sell it, and they made it so they own it. But society also has a right that it may be reused in other fashion. I mean, we wouldn't have Cinderella if Grimm's fairy tales didn't create that notion.
Well, the whole point to have copyright at all is we want more stuff. And so we think we have to protect
creators a little bit.
Protect creators a little bit so that they will produce the stuff that we need. But now we've taken the stuff away. Like, what's the point? So the question is, what's the tipping point? What does the law need to do so we do get more stuff?
Society's interest is that, we use all of this stuff to create new stuff.
Well,
by the way, this is going to become important in artificial intelligence later. But anyway, this is why it's a big deal. So Goldsmith's able to take this photo of Prince and have some rights. In fact, she did license it for $400 to Vanity Fair originally. But then they reused it 20 years later when Prince died. They reused the Andy Warhol things. And Goldsmith said, you didn't pay for that. I still have the rights to it. So the real question was, is this Andy Warhol creation protected by fair use?
And the court really botched that. And I think the reason that they botched it, well, there were a couple, that's a weird thing, why they botched it. But the big fundamental thing that I think they got wrong, and I've not seen this discussed in many other quarters, so other people may disagree, but they ended up focusing on the later license to Condé Nast as the use. But it wasn't the use of the original. Fair use applies to the use of the original, which is what Andy Warhol himself did, I guess in the 1980s when he made the adaptation of the Goldsmith picture. He used it in a way to say something new about Prince. And then he goes and he dies and he's dead for 20 years. And then later, the party that ends up owning the copyrights in his new works, the
Andy Warhol Foundation,
start to use his works, and they judged fair use based on a use of his work and construed it to be a use of the original. And I think that burned down an awful lot. And I think that's a really big deal. And I think it's a really big deal that will blow up on copyright owners because they are a copyright owner in his subsequent work. And sleeping on something that they own, they think is fine, and later they go on to actually exploit the copyright in something they think they own, and then they're going to be called on the carpet to say that the thing you thought you owned actually turns out, I guess, to be infringing. And now I think it leaves the question of, well, then, are they liable for infringement to Goldsmith? Does Goldsmith inherently own the Warhol work? Because even the court leaves the door open to the fact that Warhol himself, when he made that adaptation, may have actually been fair use for whatever was filling his mind about what his motivation was. Like, this is not a sustainable rubric for understanding these things. So is the court.
Yeah.
So there's a picture.
Mm-hmm.
Goldsmith owns the rights to that picture. Andy Warhol makes those.
He adapts the picture.
Adapts it.
Yeah.
That's okay, according to the court.
It could be, according to the court.
Because that's transformative.
As they ran their 4-factor analysis test, which is the things that courts used to use, that's now in the statute. As the court did it, it said, well, based on facts that are not present here, yeah, he still could be considered fair use.
It's fair use because it's transformative.
It could be.
Who's at fault? So Goldsmith sued the Andy Warhol Foundation over the publishing of this these pictures in Vanity Fair.
The licensing of the Warhol version for Vanity Fair.
So her contention was, well, Andy could make these pictures, but the Andy Warhol Foundation may not license them.
Apparently, somehow that was different.
Okay. And the court agreed.
So
the court isn't saying you can't make transformative works of somebody's photograph, but you can't license it?
I mean, it's very strange what the court is doing. I mean, let's say, I think there's a huge fundamental problem with the way the court ends up viewing the term use and where the fair use is, because it's really about the copier's use. And this idea that the Warhol Foundation was somehow the copier when they didn't make the work, they just ended up owning the rights of the work that Warhol made. So Warhol is the person who made the use of the original, and arguably fairly, because he used it to say something else. So I think by breaking it down, you break the sustainability of copyright law, including for copyright holders. But it was also done, and the other really toxic thing about this decision is this idea of, well, how dare you make money from it? That when they ran the 4-factor test about commerciality, it just basically meant that it resulted in, if you make of fair use for free, you're fine. But if you want to make money from it, you're not fine. But that matters.
This is what Sotomayor wrote. She said, Goldsmith's original photograph of Prince and the Andy Warhol Foundation's copying use of that photograph in an image share substantially the same purpose, and the use is of a commercial nature. Because
it was like, oh, you're just making pictures of Prince to license to a magazine, as if these are both two same things.
But Warhol did not make that picture to license to a magazine.
No, so somehow his intent 20 years later
was not commercial.
Is construed to now be the Warhol Foundation's. None of this makes sense temporally. But the other thing, and actually I need to criticize Kagan, who wrote a really scathing and correct dissent. There's 87 pages of this PDF that got produced by the court. I did a search for First Amendment, and I've also read it. I don't think the term shows up at all. And the really important thing about, like, what is the goals and purpose of copyright? We're trying to stimulate the creation of more of this stuff. But part of the reason we have fair use is because it is the codification of the First Amendment interest. Because what are we doing with exclusive rights, taking away what the public can do, but essentially impinging on expression? And the First Amendment still exists even in the wake of copyright. And there's other Supreme Court precedent that talks about how fair use is the vindication of the free expression values that the First Amendment is making sure that Congress doesn't get to step on. And they're stepping on it, because now all of a sudden, if you want to make subsequent expression that uses something else that came before, you're going to be in trouble, especially if you want to monetize it. And there's nothing in the First Amendment that says you don't get to make money off of your expression, because on something you have to, because it's the only way you're going to keep the lights on. This is a mess.
Justice Kagan and Chief Justice John Roberts were the two dissenters.
Right.
She said it will stifle creativity of every sort. It will impede new art and music and literature. It will thwart the expression of new ideas and the attainment of new knowledge. It will make our world poorer. That's accurate.
Absolutely right. And I don't understand why Justice Sotomayor, who normally is one of my favorite justices, who normally sees things really clearly in all their implications, is so blind to this. And it
seems to be the difference is this commercial use.
I mean, that seems to be the thing. The photographers, like, I made a picture and I didn't get to license it the second time around because there was a second picture that used mine. So I lost a market opportunity, and that was not fair. And that's basically what the court is like. You're right.
That's one of the 4 tests, right? Is it doesn't that the derivative work doesn't impinge on your market opportunity.
It's not the way it's phrased, and so that's part of the problem. This case was like, what do the 4 factors say, and what do they end up meaning? Because the effect on the commercial market of the original work matters for the inquiry, but the degree it's supposed to matter is, as Kagan pointed out and the foundation would point out, it's not supposed to eat the whole, because the first factor is about, was it transformative? Did it bring something new to the table, a new message? And what Kagan is screaming at Sotomayor about is like, of course it brought something new. So when Condé Nast had a choice about what image to run to illustrate their story,
they wanted the new one.
They wanted the new one.
They didn't want the photo.
Because they say different things. They illustrate Prince, the musical artist, in a very different way.
It is the case that the first test, and this is from 17 U.S.C. 107, in determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include, doesn't mean limited to, but shall include, the purpose and character of the use, including whether such use is of commercial nature. I mean, it does say that.
It does say that, and what this court has done is interpreted it in a way where it just eats the whole and shuts everything down. It also makes me wonder what happens to the author of an original work who made it with no intention to modify it. Is all of a sudden their copyright weaker than somebody who produced a work to modify it? Court doesn't answer that question. I mean, there's a whole lot of hand-waving over some really significant issues that are not addressed by this court. I don't
How
understand.
sweeping was this decision?
So we're not entirely sure. This may be a decision that is so bad it might end up being a nothing burger because no, it is a precedent, but it may end up being so weird that basically everybody just ignores it and we carry on with stuff as we did. So that's one Pollyanna-ish take. I've seen some of my friends who try to advocate for fair uses and things like that talk about how, well, it's kind of rested on its facts and it's more narrow, that, commerciality is an important thing. And so that will, in theory, help a lot of the more nonprofit uses that don't want to get obliterated by litigation, that if you take the money out of the equation, in theory, this decision doesn't really hurt them. I just think it makes such a mess out of everything doctrinally that we are all in trouble, including the copyright holders.
So this is kind of like, okay, let's say, so Michael Jackson did a song called Bad. Mm-hmm. Weird Al Yankovic did a derivative work of it called Fat, which is fair use. Actually, he got permission from Michael Jackson. He
tends to get permission.
But that he didn't have to. That's probably fair use.
Probably he's never litigated it.
Okay.
He doesn't litigate it. He had one song, I think, where he didn't get the permission and they got mad at him, so he felt bad.
Let's say then I played Bad on the show or rather Fat on the show to talk about weight loss. Let's say I played it in the new Mad. Now, it would make sense if Weird Al sued me because that was his song I was using. But if the Michael Jackson estate sued me, saying, well, that derivative work was based on Bad, so you screwed us, but I wasn't using it to illustrate Bad, I was using to illustrate Fat. Is this kind of analogous to what we just saw? And by the way, I'm doing it commercially because I sell ads. It's for an ad.
I think the upshot to this decision is that could be a problem, and I don't think that's the way copyright's supposed to work.
Which is a weird problem.
It's a weird problem, and I don't think the court addresses it. I think the court creates that problem, and I don't think that's a vector of litigation liability that's necessarily existed before where we've really had to contend with it. I mean, we're always in a problem of, did you play the song and did that infringe on the copyright based in the song? But I think what they're basically saying is, yeah, I think that's actually a really good analogy of what they've just set up.
Even the original work has some
the Michael
rights.
Jackson copyright holder could come after you for having played a derivative work.
A derivative work.
Because that may have been fair use in that context, but it's not fair use in the context.
Yes, because I'm doing it commercially now.
And that's going to not help your four-factor analysis, but that because you use the derivative, that the copyright holder in the original has some cause of action against you.
That's the same thing that happened just now.
I think that's, and I don't think it's supposed to work that way.
That's very interesting.
Yeah.
I've heard a theory that with this case, there might have been a factor of kind of like modern art. My kid could have done that, which kind of
well, that's the question is, did they accept that was a derivative work that Andy Warhol did? I think they did accept that Andy Warhol's work was fair use, right? That his work itself was fair use.
I think they said it could be. I mean, and in theory, that wasn't necessarily the facts brought to the case. They weren't talking about what Warhol did to the original, because that wasn't what the litigation. Well, it ended up strange. Somehow it should have been maybe what the litigation was about, but somehow it ended up not being what the litigation was about by the time it ended up at the Supreme Court. I'm wondering how this happened, and it seems like the court got so fixated on the four factors and how it wanted to interpret the commerciality aspect of it that they just got so lost in the four factors that they lost the forest for the trees in terms of what is actually going on here and what is the implication.
So unfortunately, what they've done is they've really muddied the whole concept.
I think they've muddied things in a really disastrous way because somebody owns those Weird Al copyrights, and I don't think they're going to be happy to know that they might be in trouble based on issues raised by whoever he parodied in the first place. And I think that's a vector of attack that this decision sets up.
That's really
I also think it's really interesting to think about how this is going to have implications in tech, because I mean, what's going to happen with all of these like AI Drake voice situations, or I've written about fair use and copyright law a little bit in the context of fan communities. Like, there was a Bridgerton musical, and
That's right. They got shut down. That was on
Netflix,
TikTok. Yeah.
Yeah, but that actually, so I had written about the case when Netflix had sued the people that created the Bridgerton musical, which was basically just like these two songwriters on TikTok writing songs like in real time on the app. And then they made an album, and then the album won a Grammy, I believe.
Yes.
But I think they settled the case because, I mean, I might be wrong, but the last time I looked at it, I think they settled the case. But there are a lot of precedents, there's a lot of like conversation about this in the context of like fan fiction, where Archive of Our Own, which is like a really big fan fiction website, they literally were like created in tandem with copyright lawyers to figure out like how can we protect 16-year-olds writing about like whatever book they're interested in, when it's like you can't even link to a Venmo or like a coffee on AO3 because they are so afraid of getting sued.
Netflix settled, so it really, we don't know what happened, and the court never got to decide on this. Netflix settled, but that's a really interesting case.
And I think similarly with what we were talking about with government officials making legislation about the internet when they don't really know how the internet works, I also feel like that happens with art to an extent, where like you could write a dissertation on whether or not this Andy Warhol work is like just copying or if it's an original work. And I mean, I think it's original.
Court wasn't really thinking about that. That wasn't really the issue, was whether Andy's work was derivative or not.
They were thinking about it so focused on the photographer that she took a picture to be licensed in a magazine. She was putting her product in the to be licensed to a magazine market space, and a magazine comes along, wants a picture of exactly the same thing that she had taken a picture of, and the court was deeply offended that the subsequent work could somehow take that market opportunity from her, because the court just treated them as equivalents. And Kagan in the dissent started screaming at the majority of like, they're not equivalents.
That's a derivative work. And similarly, Netflix
that said different
things.
Netflix
loved the Bridgerton parody when it was on TikTok. But it wasn't until they went
to the Kimmel Center.
It wasn't until they went to the Kennedy Center and had a ticket price for a paying concert that Netflix said they crossed the line that they had tried to establish with Barlow and Bear, the creators of because Netflix has its own Bridgerton experience, and so in the minds of Bridgerton fans there was a confusion between the derivative work and the original work.
So one other thing that ends up happening in this space is there's other things that can go wrong, like passing off or rights and publicity issues. Like there's other things that sort of offend us as like, wait, maybe that isn't a thing that should happen, but it isn't copyright that solves that problem. It is other legal doctrines and other legal rights that might solve the problem. And we tend to just throw it all under copyright, let copyright fix it, but it ends up contorting copyright, so it stops doing what it's supposed to do.
We need a public space. We need a public domain, a town square where all ideas go and can be reworked, because that's how creativity happens.
I mean, Kagan is pointing out in the dissent that we've really impinged on that like everybody, we already had to look over our shoulder where the joke was fair use is the right to hire a lawyer. Like there was already a lot of chilling. This decision really would appear to produce more chilling.
It kills the commons.
And I'm thinking about, I haven't seen a whole lot of people make the point that I just made. So stay tuned till next week where, we can see if people take issue with it. But I think it's actually the upshot, and that hurts copyright holders. So even if you buy the idea that copyright holders should have more and stronger rights, I think it just weakened them.
This episode of Tech Break is brought to you by ACI Learning. The days of boring training methods are over. Meaningful impact shows up as high engagement, which translates to optimal performance. Your team deserves to feel entertained and empowered to keep your organization secure. Fill out the form at go.acilearning.com/twit for information on a free 2-week trial for your team.